Hello, everybody. Good morning, good evening, good afternoon, good night. I don't know where you're dialing in from, but wherever it is, I hope you're having a fantastic day. You are listening to the Phia Group's Empowering Plans podcast, right? The podcast, guys, this is being recorded, so if we screw up, we can always go back and when we post edit, we can take it out and change it, right? Our podcast. What do you? Oh, this is the webinar. Oh, it's live. Oh, well, okay. Well, in that case, let's make sure we're careful and we get everything right the first time. So you are listening to the Phia Group's Empowering Plans webinar for January 2019. We're so happy that you're here with us. The subject for today is the Affordable Care Act in 2019, and I look forward. I'm assuming this webinar is going to be very short. I know we've set aside an hour, guys, but since the ACA is illegal, right, obviously this entire webinar is no longer important, and therefore we don't really need to talk about it, right? Come on, I'm just kidding, guys. So obviously there's a lot to talk about, not only as it relates to the ACA, but just the state of the industry in general as of now, what we see coming down the pike for 2019, and what you need to do regardless of the role you play in the industry to prepare for the year. So this is a very special webinar, very special presentation, and we're so glad you're here to join us because I think this is going to benefit everybody who's engaged and involved today. So without further ado, let's look at who's on the webinar. One thing you might have noticed is my clear and melodious voice. Don't adjust your volume. This is Ron Peck, Senior Vice President and General Counsel with the company. Say hello, Ron. Hello, Ron. Adam is actually not going to be able to join us. Originally, I was thinking we would put an X through his picture or maybe just remove it entirely. But guys, in all honesty, he is here in spirit. I still sense some of those onion potato chips we were enjoying in our meeting yesterday. So he's still with me in my heart, or at least heartburn. But hopefully we'll do him proud. He's actually on the road dealing with a bit of an emergency on behalf of the company and the industry. So he never stops working, and we appreciate what he's doing. And unfortunately, he's going to miss participating in the webinar, but I assume he'll be listening wherever he is. Two people who actually are with us are Jennifer McCormick, Vice President of Consulting. How you doing, Jen?
Hello.
And Brady Bizzaro, who, I got to tell you, Brady, I was talking about the meeting yesterday and how we were chowing down on some potato chips.
Right.
We had some outsiders visiting the office, and they truly believe that your name is a stage name. They can't believe that this is for real.
I get that a lot. I hope they're not on to me, though.
It's a combination of both the name and the alliteration. I mean, you're checking all the boxes with this thing, so it's awesome. So speaking of things that are awesome, let's quickly look at some of the pre-webinar announcements. First and foremost, LinkedIn. Listen, we've been asking everybody who listens into our webinars and podcasts to follow us on LinkedIn since, I don't know, 2014, 15. Probably we've been asking people to follow us on LinkedIn before LinkedIn even existed. We knew it was going to happen someday, and we just predicted. If you are not following the Phia Group on LinkedIn at this point, you never will, okay? So I'm tired of asking. It's like flat earthers. You could explain why they're wrong and try to change their mind, but ultimately, it's not going to happen, so why waste the effort? So frankly, if you're not following us on LinkedIn, I'm done with you. You're dead to me. Next slide, Brady. So Phia certification, we announced a while back that internally we've been going through a new training process with our staff. We're very proud of it. Phia certification levels 1 and 2. I'm pleased to let you know that everybody at the Phia Group, other than new hires for the year, have been Phia Level 1 certified. So that's awesome. The people who were required to take Phia Level 2 have done so. So again, every person you're talking to at the Phia Group has achieved that next level of industry education and certification. So we're very pleased. Level 3, the gauntlet begins this year. A few select people in the office will be undergoing Level 3 testing. And I'm looking at a couple of the people who will be undergoing Level 3 testing this year right now, Brady and Jen. So get excited. I know a few of you have been thinking that it's never actually going to happen, but it's going to come and get you when you're least expecting.
I'm looking forward to it.
Oh, are you? All right. Everybody who's listening in, she's looking forward to it. So we'll see how that goes. So time for our special shout out to Nicole Johnson at Lucent. Hi, Nicole. I feel like every time we do one of these shout outs, we have to sort of one up the last time. We have to we give these awesome gifts to people, right? Send them a goodie bag or something like that. I'm thinking we really need to turn the game up to the next level. Brady, what do you say after this webinar? You take your used notes, which I'm looking at right now. You have a stack of just webinar notes in front of you. Take them, throw them in an envelope, and ship them over to Nicole. Sign it, autograph, and there you go. So I think that will be a lot of fun, is if we actually take one of the game-used equipment and send it to the fan.
I think so. I think we should also ask these people to tell us where they're listening from. I have people they've said that they listen to our podcast while they're running, or they're at the gym, or they're walking the dog. I want to hear about that too.
Really? Okay.
I do.
You like to visualize. Well, speaking of the podcast, I don't know about you, but my 2019 New Year's resolution is pretty much to deprive myself of everything that's enjoyable, right? You're going to lose weight, you're going to exercise, you're going to get up early, go to bed early. So the one thing I'm not going to deprive myself is the podcast. This is a guilty pleasure that everybody can actually enjoy and grow and gain from it. So if your resolution for 2019 was to do something that you're starting to regret already, the one thing that you absolutely should regret is not listening to the podcast. So be sure to tune in and check it out.
And we got someone saying they listen to them on their morning commute. See, I knew it was useful for something.
Oh, that's great. And they typed in the answer there, so hopefully they pulled over or something like that. Plus, it's a little late for a morning commute, but who am I to judge? So Faces of Phia, this is something we've been doing for a while now, and I'm very proud of it. We interview a number of these people. Actually, Hemant and Tori right there have already been interviewed. I think Tori's podcast was actually just posted, so hearkening back to the last slide, be sure to tune in. These are generally people who keep the company running, but who have less client interaction than the people that are speaking to you right now. And so it's very important for us that you all really get to know these Faces of Phia, understand that it's more than the Jen Brady, Ron Adams show, and that these are really the people, sort of the iceberg beneath the waves, that are keeping things going. And they're amazing people, and it's really important to us that not only they get recognition, but that you get to meet the people who are working every day on your behalf. So speaking of people who are working on your behalf, I'm a little regretful that Adam is not here today so that we can congratulate him to his face. And yet at the same time, I'm very glad he's not here and we don't have to congratulate him to his face today. Adam has been named to the board of directors. He is the chairman of the board over at SIA. SIA, as you know, the Phia Group has been involved with this association, this organization for many, many years. We really appreciate the work that they do on behalf of the self-funded industry, from working with Congress people to get laws passed, to advocacy at the state level. There are a number of states in particular that have been taking action lately to limit self-funding, to attack stop loss, really things that aren't good for anyone who's on the line or the employers we work with or their employees and their families. And SIA is always at the front line. So I'm very proud of what they've done for us, and I'm very pleased to see that Adam is taking this leadership role with the organization. I believe he's going to take the energy and sort of innovative thought process that he applies here at the Phia Group and bring it to SIA. And you already see with the Future Leaders, I know, Brady, you're very much involved with the Future Leaders crew over at SIA. We're already starting to see new campaigns and new efforts there that are fresh, that I think are bringing new energy to the industry. So if you are not involved with SIA, but you are involved in the self-funded industry in any way, shape, or form, it behooves you to at least learn a little bit about the organization and consider working with them. So a shout out to my friends there, and congratulations, Adam. So last but not least, look at the overview. These are just some of the things we're going to cover today. I'm not going to waste any time going through there. You're going to learn what that's about. But before we get started, everybody has to sort of keep the final destination in mind. I don't care which way you go. I use the Waze on my GPS on my phone, and sometimes it tells me to go home this way, sometimes that way. Hopefully it's actually redirecting me around traffic and accidents, and not just trying to gather new information on roads it doesn't understand or recognize. I'm a guinea pig, right? But it doesn't matter which way you go as long as you get to the same final destination. And I know for us, our final destination is to address some of the overarching issues that are impacting the industry. In particular, for whatever reason, and I think everybody agrees more or less, healthcare it just costs too much. And whether you're talking about the cost of care or the cost of benefits or whatever, it's all too expensive. And ultimately, the people that we serve, the employers and their employees and their families, deserve affordable health care. So how are we going to accomplish that? I don't necessarily think the things that we do here are the be-all, end-all, are going to solve all the problems, but I do feel confident that we're at least contributing to the solution. And everybody who's listening on the webinar right now, by listening, by getting further educated, by taking proactive steps and measures to make 2019 a better year for you and your clients, you're doing the same thing. So I think we all have that same final destination in mind. Now let's talk about the avenue that we're going to use to get there. And when it comes to navigating and telling us where to go and how to get there, there's no one I trust more than Jen McCormick. I do what I can. Thank you.
All right. Well, happy 2019, everyone. Let's talk about our December 2018 FAQs. Okay. Number one, can you clarify what it means to be a non-ERISA self-funded plan? Are there any sort of regulated, fully insured type of rules that need to apply, or are there specific blanket rules that I need to be aware of when it comes to a non-ERISA type plan? So when we're talking about an ERISA versus a non-ERISA plan, in general, a non-ERISA plan is one that doesn't enjoy the types of preemption from ERISA like a traditional ERISA plan does. So that means that they are going to have to be potentially subject to specific laws within the state where that plan is located. It does not mean that because they are non-ERISA that they are a fully insured plan or are subject to every single one of the fully insured laws. It just means that there's not a blanket answer to this question. And if you are a non-ERISA plan within a specific state, you're going to need to take a look at that state's laws to make sure that there aren't any specific rules or regulations that you need to address or make sure are handled as part of your plan document or summary plan description. Number two, what are our obligations as a covered entity under HIPAA for providing notice regarding our privacy practices? This is what we like to call the NPP. So a notice of privacy practices, there are specific requirements under the code for what must be within those actual provisions, and I'll just highlight some of the points of those actual notices without actually reading them. If there are more specific questions, always feel free to reach out to us and ask us these questions, and we can provide you some more detailed responses. But in general, in order for someone to know that they are receiving the NPP, there has to be a header, some sort of notification that someone realizes that the document, the provisions they're reviewing are actually the notice of the privacy practices. Also, there are specific reasons that we have HIPAA and PHI protections in place, right? We need to make sure that information is only being transmitted if it's for treatment, for payment, or for plan operation purposes. So we need to make sure that that is notified and part of that NPP notice in the first place. Also, there's a caveat that if the plan in any way is intending to use that information for underwriting purposes, that information is that's disclosed on the document as well. Also, there is a laundry list of duties that a covered entity has to abide by, and those are specific things that should also be outlined within the notice, as well as the effective date and contact information. So if there is a problem or a concern or a potential complaint about some disclosure issues, maybe a PHI or a potential HIPAA breach, there needs to be a contact that that individual can reach out to seek some sort of resolution. And last but not least, maybe the most exciting question up here, what are the most important considerations for a plan that wants to cover medical marijuana? Now, this has been a big issue, right? Especially here in Massachusetts, where you have to have a special shuttle service for people to actually go and visit these new shops as they're opening in the first place. This is a big deal.
It's, as far as the issues that the consulting team are dealing with, this one's pretty high on the list.
Pretty high on the list.
You're welcome.
We can count on you for, Ron.
Yeah, you can count on me.
So the first thing to remember, as states are starting to legalize marijuana and medical marijuana is becoming more common, that doesn't mean that marijuana or medical marijuana is still legal at the federal level. This is still a narcotic on the federal level. So even if a state has legalized the use of marijuana, or you can get a prescription to use medical marijuana, it is still not, it's still an illegal drug at the federal level. So if you're making these modifications to your plan document, one of the things that you're going to want to look at is taking a look at the definition of drug. Does your definition of drug reference an FDA-approved drug? Well, guess what? Medical marijuana is not an FDA-approved drug yet. So you're going to need to make sure that you're making modifications for that. Also, we talk about gaps and stop loss issues all the time. Could it be that if you cover this under your plan, that you're creating a gap for yourself, that maybe while this would be covered under the plan, that this would not be eligible for reimbursement by stop loss? And what about potential tax issues? We know this isn't a drug, so it's not an eligible medical expense. So if you're paying for this as part of the plan, should there be an audit, no matter how high or low that opportunity or that chance could be, there's a possibility that someone can come back and say that you paid a plan and created an unintended tax consequence. So there are certain considerations before just deciding to cover a benefit under your plan that you should look into before making those modifications. And again, if any of these questions or any other questions that you might have, always feel free to reach out to us and we can see how we can help out. And I'm going to turn it back to Brady, I think. All right.
Thanks, Jen. So, yeah, we can talk about a special political update today. I think this is the first webinar we've ever done when the government's been shut down. I know there's been a lot of threats, but look, this is a serious deal. It's day 26. There's no end in sight. There's tons of news stories about how this is impacting, real Americans in terms of people aren't getting paychecks and other impacts. But our industry is impacted. I want to dispel the notion that we're safe. You might show up to work and think, ERISA is still the law, the DOL is still functioning, HHS is still funded, but there are a number of agencies that are impacted by the shutdown, and there's been in one case directly, but if nothing else, there's a trickle effect, and I want to just go over some things about how the impact of the shutdown is affecting our industry. So as I mentioned, HHS, it's all set and that it's funded through September. So direct enforcement of Obamacare, of Medicare regulations and Medicaid, that's all insulated from the effects of the shutdown. However, there are agencies that are not. The IRS is one of those. And before I talk about how it could impact us, I want to point out that, yes, they're still going to enforce penalties, so make sure you're still complying with the employer mandate, make sure you're still complying with your other reporting requirements. That's going to be kept going. And I think I just read this morning that the government is actually ordering a number of agents back to work at the IRS to process tax refunds, so that's good news for us. But that means more agents will be working probably for free for now to enforce penalties. However, the IRS essentially plays the role of an accountant for the ACA marketplaces, which has 8.5 million people enrolled in them. And so they do important jobs like calculating the eligibility of Americans for subsidies under the ACA. So that could be seriously impacted. So you might have a situation where people aren't getting coverage or they're not being able to afford coverage because the IRS is not able to do those calculations of eligibility. That's a big deal. Also, the IRS can't review 1332 waivers, which were waivers under the ACA that the Trump administration permitted that allowed states to make changes to how they run their exchanges. For example, setting up reinsurance programs for high-cost patients. So that could be impacted, and that will have a trickle-down effect. If insurers are paying more, that'll affect the self-funded industry. That's a problem. The FDA is another one I want to mention here because it's largely operational due to the fact that it's being paid for by fees that drug manufacturers pay to the FDA on their applications. But because the FDA can no longer accept new applications, that money could run out. And if that happens, it could jeopardize new drug treatments that are being planned and tested for depression, for diabetes, and other diseases. So that could be impacted. Interestingly, the Indian Health Service is directly affected by the shutdown because it's funded by the Interior Department, which is currently shut down. So there are many services which are not happening right now for tribes around the country. So things like there are health clinics where staffers aren't being paid, grants to IHS that support tribal health programs and preventative care clinics. Those aren't being approved. And so it's really because the IHS is classified under the Department of the Interior, they're being hit harder. And finally, I want to mention the DOJ. And as we're talking now, there's a hearing happening in Washington for the new or the proposed nominee for Attorney General, William Barr. And he'll be important because he will be spearheading the appeal in the case that Ron mentioned at the beginning of the webinar, which declared the ACA unconstitutional. But interestingly enough, while the shutdown plays out, the appeal can't be heard. So it's going to extend the duration of confusion and this phase of limbo that we're in. So I think it's interesting that we have a new Congress. It's January. Everyone's all excited for a new year. And this shutdown is really impacting everything and everyone, including our industry. We'll keep tabs on, if like the FDA, for example, runs out of funding, that could be a big deal. And we'll keep you guys up to date with any impacts on that. The other big political story, aside from the ACA, by the way, is the coming pharmaceutical drug pricing wars. This is a big deal, and if you've been following our webinars or reading news articles about healthcare in general, you'll know that this is one of those issues we talked about earlier as being a bipartisan in nature, and one that's likely to see action this year. And our industry, self-funded plans in particular, are affected by high drug prices. Everyone on this call, or most people on this call, probably knows names like Harvoni or Sovaldi, which are drugs that could cost $30,000 a month or more to treat hepatitis C. Drugs for other rare diseases, the increase in prices are just happening through the roof. These new drug makers, the drug makers rang in the new year by raising prices across the board. That's despite the administration pretty much laying down the gauntlet and numerous tweets and agency proposed rules announcing that they're not going to stand for drug price increases. You still have them happen. We talked about last year the blueprint that the administration released called American Patients First, which implemented a couple of proposals, including repealing the gag law that lets pharmacists now discuss alternative treatments with their patients. But that was a plan by the administration to really take a look at initiatives that they think are causing the increases, things like discount copay cards. They're considering fiduciary status for PBMs. That would be a huge deal. But two other things I want to mention here is that the Democratic Congress, which now has new power in the House, one of the important committee members there is a man called Elijah Cummings from Maryland, who is leading the House Oversight Committee. And he just met yesterday with the HHS Secretary to discuss ideas for lowering drug prices. And so that's scaring drug manufacturers, because you have a Democratic House, a Republican-controlled Senate, and the president all together taking aim at them to reduce prices. And they're investigating more than a dozen manufacturers like Eli Lilly, Johnson & Johnson, AstraZeneca, Pfizer, Novo Nordisk, all being investigated for why they raised prices, or they want to know justifications for why they did this. Because, look, to be clear, the administration cannot directly impose price controls, but they can still take actions. And one of the actions that they're looking at for next year is tying Medicare Part B prices to an international pricing index. That's important because Medicare is the largest purchaser of drugs, and it could establish a sort of Medicare-like rate for drugs going forward. That's only a proposed rule, and it's expected in 2019 with a pilot program possible in 2020. But it's important to note that this is going to heat up this war as we go on throughout the year, that's what I'm calling it, because you're going to see legislation proposed, you're going to see rules proposed, and you're going to see a lot more tweets, frankly, that are aimed squarely at drug manufacturers, because it's really out of control, the pricing, and there's not really a good answer from them.
Brady, did you call it a war?
I do, yeah.
A war on drugs? Really?
Well, I'm not going back to the 80s for that. It's a war on drug pricing. I think we'll specify that.
To avoid some confusion.
Yeah, we already tried the other one. I'm not sure that one's working so well. But I really think this is going to be one we're going to follow, because, like I said, we all have a stake in this, especially self-funded plans, which have to bear the brunt of high costs in ways that fully insured plans don't. So, all right. One last update here before I turn it back over to Jen. And so this entire webinar is really about the state of the ACA. And don't worry, these slides will all be made available right after the webinar. So if you see a lot of content, or if I'm speaking very quickly, it's because we're pressed for time, but nobody will have the content there. So the State of the Union is happening later this month. And so I thought that was a good theme for the state of the ACA in this webinar. And I describe it as peril with an exclamation point, because it really is in peril. It's in legal peril, it's in political peril, it's in economic peril. It's really causing Obama to break out in a sweat, as you can see there. But look, anyone who's paying attention to anything happening in our industry knows that last month, a Texas federal judge, ruled that the ACA is unconstitutional. We'll talk about that in a few slides in detail, but that's a big deal, and it's really sent shockwaves throughout Washington and throughout the country, and we'll talk about that in a second. But political peril, because now that we have divided government, we're going to have probably more gridlock. I mean, look, as I'm speaking, the government's not even open. So any legislation that's needed to stabilize the insurance markets, or to even repeal the ACA, none of that stuff is probably going to happen right away, and we're going to be left in a situation where we're in limbo with, pot shots being taken on either side. It's kind of a big mess. Also, already you're seeing a number of candidates declaring that they're running for president next. It just seems like we just did this. And because of that, it's heating up the rhetoric on both sides. And you're going to have, I think, much more difficulty for bipartisan answers here. Unlike prescription drugs, on the ACA, it's going to be a complete mess. And you're going to see more executive actions that the administration will take to weaken the ACA, I think, or to propose alternative insurance markets like association health plans, like trying to deflate certain parts of the ACA, like the contraceptive mandate, which Jen will talk about later. So in the end, it's really in peril from all sides, and that's the theme of the webinar. But before we talk about how much peril it's in, I think it's smart to go back to the beginning, to the roots of the ACA quickly, and for that, I'll turn back over to Jen.
All right. I just remember when ACA was coming into effect just 9 short years ago.
They grow so quickly, don't they?
They do. Back in 2010, actually March, so almost exactly 9 years ago, we were at the point where there was this brand new 2,000-page law with a bunch of gradual phase-in modifications and requirements that were going to need to be made to plan documents. And this was landmark legislation 9 years ago. The point of this was we wanted to increase access for the number of individuals who could get care. We wanted to figure out a way where we could make this more affordable for many people. We wanted to have lots of different opportunities for people to get health insurance. And if we remember quickly, this was modeled based off of Massachusetts. So this was an important time. This was a really important thing. This had been the biggest change in healthcare and the way that health insurance was provided since Medicare came into effect. So this picture just takes us back to when Obama actually signed this law back in March. Let's flip on. Okay. So as we know, as I talked about, there are a lot of things with ACA that people thought were going to be very important when it came to changing their plans. The individual mandate and the employer mandate. So in order to get all of these modifications to these documents, to these plans, to increase access and increase coverage, there needed to be some way on the back end that we could actually pay for these new increased benefits that people were getting. So different taxes and penalties were going into effect. 2 of those taxes were the individual mandate and the employer mandate, which are taxes, right? Went through that back in 2012.
Yeah.
So that is something that we are aware of. The individual mandate, while that is no longer effectively a tax, we still have the employer mandate that we need to be, we still have that in effect. That has not made any changes, although Brady might have some news for us based on proposed rules in a little bit. We know that our kids can stay on their plans for their parents' plans until they're 26. We make sure that no one can be denied based on a pre-existing condition. We know that there are other rules and modifications about getting access to an approved clinical trial. In general, there are a lot of good things that were added to plans for people that were an important part and have become an important part of getting health insurance today that people have come to expect as part of their standard health insurance plan. One of the most important things, which we've all kind of talked about a little bit, is getting certain preventive services, particularly for women, at 100%. So modifications to that, as far as ACA is concerned, any changes, no matter how big or small, are going to have a big impact.
So I think I talked about this at one point during a podcast, Brady. I talked a little bit about how back in the 6th grade, and yeah, this sticks in my craw. That was a long time ago, and it gets longer every day. Actually, tomorrow's my birthday. Can you believe it? Yeah, a little bit.
Birthday.
There you go. No better way to celebrate than a webinar. So I remember in the 6th grade, I won. We had a mock election, and I won, and I was the president of the 6th grade, and it was the best. And I remember, just like 6th graders do, we based it on real subject matter, real hard-hitting topics, and we covered all the important key issues that were affecting us at the time. And then the next year, junior high school, it was time for student council, and I ran an election, and I was positive I was going to win, right? Because I'm the incumbent, right? Easy peasy. And I lost, and this still strikes me to this day, because the person I was up against, they were promising things that nobody could possibly deliver, and he certainly wasn't explaining how it was going to be paid for, longer breaks, shorter classes, better food, right? None of this actually happened, but man, oh man, those promises, I almost voted for the guy. And it's funny because now I look at this list of things that people generally, as they're polled, like about the ACA, and things that they don't like about the ACA. And when I look at the left, I see the list of promises that junior high school competition there was listing, because, again, look, if you really had to summarize it, basically you could break these out into 2 silos. Silo number 1, things that cost money. Silo number 2, things that make money. And as you look down the list, you'll note that people like to receive things, but when we propose how we're actually going to create funds to pay for those things, people generally don't like it. And I wish I could say it's limited to the ACA. It's not. Generally, when we talk about health benefits and health care, Brady, I know we did a webinar and a podcast not too long ago regarding the results of the election.
Yeah.
And we talked a little bit about how some of the questions were struck down, others were supported, things that basically they were asking for something and telling people that they'd have to pay for it, whether it be through tax or something else. People said, hey, no way, like back off, don't touch my wallet. But was, hey, we're going to give this to you for free and we'll figure out how to pay for it later. Everybody was all for it. I think you start to see that same issue coming up in the ACA and otherwise. So again, I'm not necessarily saying that we can go out there and teach people to be responsible and understand you can't get anything for free. But at the same time, as we proceed with development and creation of our own innovative benefit plans, keep in mind that when people see that they're receiving something, it tends to be well received. And if it looks like you're going to be pulling something, it tends not to be well received. And I know we'll talk a little bit later about, for instance, PPO networks and versus direct contracts and steerage and things like that in innovative ways to reduce the cost of a benefit plan. And the thing is, you look back, and Adam used to use this example all the time, when the Massachusetts, the MBTA, public transit, their self-funded plan, it's a union plan, they basically terminated their network and started negotiating a brand new network, and they wanted to narrow that network. So they would get a better deal with the in-network facilities, and they would carve out the facilities that didn't agree to their terms. And there was a lot of backlash from the members of the plan and the union because they felt like they were having options, right? This hospital, that facility is being taken away from me. And it really all had to do with how it was being communicated to those plan members. So as you look at this list and you think about your own plans, think about how you're communicating what's being provided versus what the costs are, and really try to think about how you can kind of cue it up so that everything is cast in a more positive light, because it does make a difference. So speaking of things that have been cast in a negative light, I call this the death by 1,000 cuts, all right? Originally, you recall during the presidential election, President Trump, he was talking about how he's going to repeal and replace Obamacare, and it was sort of like, I'm going to knock it out with this 1-2 punch, and it'll be out of here. And it didn't really happen. And so I think that as we do these webinars and we do these podcasts and you read the news, one of the things that you're definitely starting to notice is this erosion of the law. Like I said, death by 1,000 cuts. You talk about the individual mandate, right? People would agree that more likely than not, that's one of the important things when it comes to insurance, is that you get healthy people who are not necessarily going to draw from the risk pool, but are going to add to the risk pool. You need that money. The money's got to come from somewhere. Well, now you don't have the individual mandate. So again, you want to talk about adverse selection. Pretty soon you're only going to have the people who need the insurance paying for the insurance, but honestly, that's not financially, fiscally viable. You talk about, we talk about skinny plans and association health plans, and even people talk about just self-funded plans and ERISA, all as alternatives to the ACA-created exchanges. Again, adverse selection. I'm a huge advocate for self-funding, but there are a number of advocates of the ACA who look at self-funding and they basically say, oh yeah, you've got all these healthy lives, you're going to hoard them and keep them for yourselves, but the moment your employee population is too costly, you're going to open the floodgates and let them flood the exchange. And there's this concern that there's this adverse selection, and as a result, a lot of people are attacking self-funding, not because a self-funded plan is good or bad, but because they see how there's this wealth of lives, of risk money that can go into the pool that would benefit the exchange and the ACA in general. So again, you look at all these alternative options, we as professionals in this industry think, hey, this is a great option for this plan. That's a great option for that plan. At the same time, we're not necessarily looking at how it's going to have an impact on the ACA. But let me tell you, supporters of the ACA, they are looking at how these things are going to have an impact on it. Speaking of things that have impacted the ACA, let's now turn it over to the Honorable Judge Brady.
Thanks, Ron. So this probably is the single biggest thing that has impacted the ACA to date. And I encourage anyone listening to the webinar here, there's a more extensive write-up of this opinion on our website. We did a blog on this. We've written about it, spoken about it on podcasts as well, but I still want to go over here some of the details of this case. Basically, what happened in this case, it was brought originally by a number of Republican attorneys general from about 18 states, and actually governors as well, back in February of last year. They were challenging the constitutionality of the ACA. And what they essentially said is, look, the individual mandate penalty has been zeroed out. Without that penalty in place, the rest of the ACA must fall. And the ruling that came out last December, December 14th to be exact, in a 55-page ruling, Judge Reed O'Connor in Texas, a federal judge, agreed. And his opinion had two elements, and I'll just briefly read them as he put it. First, he contends that since Congress reduced the ACA penalty to zero, the mandate to purchase insurance must be invalidated. Then he says, since that mandate is essential to and inseparable from the ACA, the whole 2,000-page health law must be struck down. So this really brought to the spotlight this issue of severability, because typically when laws are written, in the law itself will be a severability clause. In fact, the law known as Medicare and Medicaid, the actual text of the bill has a severability clause saying if any part of this bill is found to be illegal, the rest of it shall stand. Now, when the ACA was passed, if you can imagine, 2,000 pages, no one thought to insert that kind of provision. So that's one of the rationales this judge used in rendering his decision. But I want to just back up for a second and just note why this case was kind of inevitable, because when it was announced, it was not the first serious legal threat to the ACA. Obviously, we had the big case in 2012, and since then there was an important case called King versus Burwell, which I have up here. But it's the first case in which the administration, now Republican administration, said it would not defend the ACA. So literally, you had to have Democratic attorneys general stepped in from 16 states to defend the ACA in court because no one else was going to do it. And by the way, since then, the Democratic House has also announced that it will intervene in the appeal that's forthcoming. So is this case a big deal? What do we think about how likely it is to stand? The first part of his analysis here, that the mandate can no longer be reasonably considered a tax, I think is compelling because clearly there's no penalty associated with it. And the entire foundation, the constitutional foundation of the 2012 case was that Congress has the tax power to enforce the individual mandate because it's a tax. But now that you have no penalty associated with it, I think it's unreasonable to construe it as a tax. And if it's not a tax, then you sort of lost the constitutional foundation for the mandate. I'm with him so far, but most other legal experts say that it's the next step that he takes that is problematic, that he says the entire law has to fall. And it's important to note that when the Tax Cuts and Jobs Act passed, Congress expressly left the rest of the ACA in place. They didn't say in their notes, yes, we think the entire law now has to go away. There was no intent written into that action by Congress. So this judge has assumed, he's reading the congressional intent saying, oh, well, they intended this to happen, and I think so. That's really why you've seen so much pushback from the legal community, that they think this guy went too far in trying to discern the intent of Congress and saying that they intended this entire health law to go away. So that's where I think this case is going to be problematic for people who want to see the ACA go away, because it's going to be appealed. It has been appealed already to the Fifth Circuit, and that appeal is on hold. And more importantly, perhaps, is that this same federal judge issued a stay of his own opinion on December 30th. So a few weeks went by after Christmas. Maybe he had some second thoughts after opening up presents and said, you know what, I'm going to stay my own ruling until this appeal plays out. But because this appeal is now on ice because of the government shutdown, who knows when this will get resolved. So we're going to wait and see how this plays out. This is going to come down to, like I said, an issue about severability and what was Congress's intent. Do we go with the congressional intent from 2010, or do we go with the Congress's intent as it is comprised now, which is divided government? It's unclear there, but my gut tells me this case will probably be overturned. If it takes the Supreme Court to review it, maybe, although if Ginsburg has an issue again and we lose another one on the Supreme Court, maybe they would go a different way. But we've already had a conservative majority court uphold the ACA twice. I think it's safe to say that they don't want to have to do this again. They'd rather Congress come up with the fixes that are necessary. So I kind of already covered most of this here, but the new case name, by the way, is Texas versus Azar, which is the name of the HHS secretary. It's no longer Texas versus United States. But most people think that this case will be overturned. And so we think so too. And with that, I'll turn it back over to Jen to talk about one of the other really big erosions of the ACA, and that has to do with the contraceptive mandate. Jen?
All right. Count on me to talk about this. All right, I'll catch everyone up. So as a little bit of a background here, we all know about the requirement for plans to cover certain preventive services at no cost. One of those required preventive services is certain types of birth control. And it's not a surprise that this has been going on, that people have had objections to covering this under their plan. So back in 2017, some rules had been issued sort of allowing for the opportunity for both an exemption and an accommodation for plans. So there was the opportunity, maybe you had a sincerely held religious belief that would prohibit you from wanting to allow certain members on your plans to have access to this. And this was going to be, that was your belief, and you didn't want this to be covered in your plan, or maybe morally you had an objection to having these types of benefits covered under your plan. Or maybe this was just something that you wanted these people to have access through, but you didn't want to be responsible for paying for it. So previously there had been these regulations that outlined the opportunity and the avenues that you could take if you were looking to have some sort of objection or an exemption for your plan, and that these individuals, women, would have to receive these birth control services elsewhere. So that was finalized, and then most recently, Friday was January 11th, I believe, the first judge in California was taking a look at these rules that had been finalized in November, and there were 13 states plus DC, and having their objections decided to request their injunction that this would no longer be a requirement. You would no longer be eligible to get these exemptions or these accommodations within those 13 states. California was one, Connecticut one, was Illinois was one, Maryland was one. Quite a few states had that. And then that following Monday, a Philadelphia, Pennsylvania judge took this a step further and also issued this on a nationwide basis. So at this point, the opportunity to get these exemptions or these accommodations is in limbo. We don't necessarily know whether or not there is going to be an opportunity for people to have these. So this has created some more friction, some confusion for plans, because as we know, these rules were issued in 2018, but just now plans have gone through the renewal process for their new 2019 policy periods or their calendar year plans. So if someone had made the decision to maybe offer or allow for an accommodation or an exemption, what does that mean for those plans now? So that puts us in a pretty difficult spot, and we'll have to wait and see how or whether this takes it to the next step. But just know that there's a nationwide hold right now on getting this coverage.
Thanks, Jen. So yeah, that's a big development, and so is this one, although it's a proposed rule, so I'll go through it rather quickly. But just remember that the ACA currently prohibits employers from maintaining a health reimbursement account that reimburses the cost of premiums for individual health insurance policies that employees purchase. So you can't reimburse your employees if they purchase an individual health insurance plan. That didn't really jive well with the employer mandate, where they wanted employers to provide coverage to full-time employees. However, nothing's finalized yet, but the IRS has really departed with that position and proposed some rules that would essentially remove that prohibition. So it would provide a future path for employers to essentially avoid ACA employer mandate penalties by permitting them to reimburse employees for a portion of the cost of individual health insurance coverage that they purchase through the exchanges, for example. So that would be a big departure and a big difference. If that happens, we'll see the target date again is 2020, and who knows what could happen. I mean, for all we know, the government will never reopen, and the IRS can't actually write these rules. I mean, we're just sort of in limbo on that one. But that would be a big development as regards to HRAs and the employer mandate, and so we'll be following that one. And now, the road ahead for the ACA. We talked a lot about all these different pitfalls and the legal peril, the political peril, the economic peril. What's going to happen? Despite all this, the ACA is still a law of the land. The president himself has said so, or he was a former Speaker of the House. It's being enforced as it is. So remember when Idaho, way back, I think sometime last year, tried to sort of change the ACA rules and regulations by having state plans. CMS at the time wrote a letter to them saying, you have to enforce the ACA or else we will. That was CMS, an agency run by the Trump administration's government. So know that it's being enforced. There was an example also in New Mexico where a ruling came out about risk adjustment that would really have destabilized the exchanges. The Trump administration stepped in and rewrote the rule. So they're protecting the ACA, despite what you may see publicly and hear. Know that's there, but also know that Democrats have new power in the House. I mentioned one committee chairman. There's a couple others that are very important on important committees. They'll be taking actions throughout the year to help protect the ACA, and so will blue states. We already mentioned last year throughout the different actions that states have taken to fill in the policy gaps and the coverage gaps that have been created by administrative action so far. Those will continue. So just know that the ACA has important people in its corner. But how do you prepare? I mean, what do you do knowing that all this is happening in limbo and it's confusing? What does this court case mean? As I said before, keep up with deadlines. Reporting requirements still apply. You have to distribute your Form 1095-C and or B to employees. The deadline was extended to March 2nd. Keep that in mind. Make sure that your official enrollment literature doesn't refer to the individual mandate anymore, because it's officially now dead in this year, and just the penalty is as of 2019. Make sure you're doing all your data collection reporting, distributing forms correctly, collecting data. Do all the things you normally do. These rulings and these effects on the ACA do not impact plan design, compliance, employee incentive programs. None of that is changing, so keep going on with them. Look out for penalty letters if you get one, and if you do, we're happy to help you sort through how to respond to that. And as well as looking at the proposed regulations. We already covered a few in this webinar, but as more regulations come out or are proposed, know about them or tune into us or contact us. We'll help you go through and see what it means for you. And we'll also weigh in on how likely we think the regulations are to become final rules, which is what really matters. And again, the most important thing to do in all this is to stay relevant. And I can't think of a more relevant person to cover this section than Ron Beck.
All right, I'll accept that. So Brady, it looks like we're going to make it at least for another year or two before the ACA is deemed to be completely illegal. And that means yet another 2 years after that before it's Medicare for all. So for at least the extent of about an undergraduate education, 4 years or so, we should at least continue to plan on offering benefit plans. And if you plan on offering benefit plans for more than another year or two, you're going to have to stay relevant. And how do you do that, particularly during this time of uncertainty? Options, options, options. Employers, our CFOs, HR, CEOs, they're all seeing the news. They see healthcare as an important issue. They're looking at their budget. They're realizing their health benefit plan is one of their top budget items. And they're saying, you know what, I need to get more involved. I need to get more engaged. I need to manage my health benefit finances the way I manage payroll or anything else at the company. And so as a result, they're either asking their administrator, they're asking their broker advisors, carriers, what can I do to improve the performance of my plan? I want to get more for less. I believe a lot of employers still see the value in offering a benefit plan as an incentive to attract talented employees, as an incentive to maintain and keep quality employees. So they see the value in it, but at the same time, they also see that it's starting to get said it's not affordable anymore. So how can you offer more for less? And a lot of that responsibility is going to fall onto the service provider. Those are your TPAs, MGUs, stop-loss carriers, brokers, us, right? The employer is not going to do this themselves. So you need to be able to offer more for either less or nothing. How do you do that? The first thing I would tell you, start doing the things that your client pretty much thinks you're doing anyway. And if it went bad, they're going to point the finger at you anyway. So chances are you should probably stop kidding yourself and realize, even though you have a disclaimer in your service agreement, chances are you're being held responsible to handle some of these things. In particular, I look, for instance, at stop-loss management and procurement. If you're a TPA, maybe you're saying, oh, hey, we have nothing to do with your stop loss. It's on you to pick a carrier and sign a policy, the contract, to disclose all the information. If something isn't disclosed and then down the line stop loss denies a claim or something is poorly written in the plan document, and these are all responsibilities of the plan sponsor, and yet the knee-jerk reaction is going to be to point the finger at the TPA. Likewise, if you're a stop-loss carrier and you're saying, hey, look, this is the policy, we protect the plan, that's it, we have the blinders on, we don't look at anything else impacting the plan but the document and the policy, trust me, there are other things impacting the plan besides the plan document and your policy. Things like employment handbooks and network agreements and direct contracts and medical tourism and vendors. Get the full picture. So again, when you're talking about data management, management procurement, understanding the full picture, providing guidance, I understand everyone says we don't want to take on that liability, but again, based on the nature of the service you're providing, your client already thinks that you're liable, so it's time to revisit and maybe take on these additional responsibilities you've avoided in the past. Now, those have to do with services. What about actual plan types, right? So the traditional network plan may be attractive to most, but I like to, and I know last time during our previous webinar, I joked about Baskin-Robbins and 31 flavors, right? The thing is, yeah, they've got rum raisin, and I don't mean to offend anyone who's listening right now, but if you dig rum raisin, good for you. I'm not saying you should or shouldn't. I'm just saying the vast majority of people don't, all right? Now, I don't know how long that carton's been sitting there, but that's neither here nor there. The point is that even though most people are getting vanilla, chocolate, strawberry, maybe a little cookies and cream if you're feeling wild and crazy, the point is there's 31 flavors, but maybe there's 5 that people actually order, but they still need to offer all those flavors. You need to offer all those flavors too, not necessarily because it's the best option for your client, but because they want to see that that option's available if they want it. This has come up a lot with reference-based pricing. I know a lot of brokers and now even employers, CFOs, people are going to these conferences, they're hearing about Medicare Plus. Especially now, down in the Carolinas, they're seeing actual carriers implementing this, not necessarily across the board, but as an out-of-network repricing solution, right, a methodology, or maybe the way they calculate in-network rates. Ultimately, the hospital or the provider is still being paid the same amount or even more, but it's being calculated based on a % of Medicare instead of a discount. They hear the buzz, and they want to know, hey, is this a train that I should be getting on, or should I stay at the station? You need to be prepared to say, here are the pros and cons, here's what it means. Maybe it's not the right option for you, but if it is, we have that option available to you. So understanding these different types of plans, making them available, that's going to be the key to staying relevant in 2019 and beyond. Again, this is a little bit less cutting edge than some of those other options, but you hear a lot about consumer-driven solutions, right? High deductible health plans. Personally, I'm not a huge fan of high deductible plans. I know some people are. I don't believe that plan participants necessarily have the information or access to information that would make them an educated consumer of healthcare. You're basically saying, here's an allowance, use it wisely, but they don't know the first thing as far as healthcare spending. They don't know what's necessary versus optional, what costs more, what costs less. They don't even know, when their physician says, oh, you need to get an MRI, to say, well, golly, this is coming out of my pocket. Can I go to, a self-standing, freestanding facility instead of the hospital MRI and save 50% off the top? They don't even know to ask it. So you can't shop around if you don't even know it's an option to you. So again, the lack of education is giving them the money and saying it's on you now. Seems a little lazy to me. I think that more important is really sort of, and this is where we talk about transparent pricing and tools to aid consumerism. I think that's also important, but information on its own is not enough either. I know in the past I've joked about how you can go to a pharmacy and you need some aspirin and people are purchasing Bayer instead of the generic, or they're purchasing Tylenol instead of the generic, even though the branded drug isn't any more effective. But again, there's transparency. You know exactly what the price is. The generic is cheaper. And if nothing else, they see a higher price and assume that means it's better. So I don't think transparency on its own is enough either. But I think if there's financial responsibility, transparency, and education about the actual nature of healthcare, quality metrics, things like that, you cover those 3 bases, now we're talking. Patient steerage, that really, I think, ties into what we've done here with our own plan. We've done a lot of that legwork. Okay, we've researched facilities, we've researched different treatment options, and instead of telling our employees, our plan members, hey, here's some money, be smart with it, instead we actually tell them, oh, it's the plan's money. This is not coming out of your pocket. But here's how to be an educated consumer of healthcare, and oh, by the way, if you make the right decision, here's a carrot, here's a benefit, right? Those EOBs, don't let them sit in a bucket somewhere in your house, gathering dust. Open them, read them, and if anything looks suspicious to you, a duplicate charge, a charge for something you didn't receive, bring it to our attention, and if our plan is able to save money, either avoid paying or get that money back, you get a % of what you discovered. Anybody can do that. Nobody knows the treatment they receive better than the person themselves, but if there's no incentive to care, why would they? So again, we've done a lot of things here at our own company that create that sort of incentive-based, positivity-based consumerism instead of a, like I said, high deductible plan. Here's an allowance, use it wisely. One of the other things I always worry about is, people think, hey, if this is coming out of my pocket, I'm going to avoid treatment until it becomes catastrophic, and then everybody loses. Or maybe they think, well, I'm going to end up spending it anyway, so I should just blow it as quick as possible and just get it out of the way. That's the other end of the spectrum. So there's all sorts of issues and a lot of research on this topic. Ultimately, how are you going to remain compliant with these changing laws between the government shutdown, the different statements coming out of these regulatory agencies, the lawsuits? 1 second you're reading an article, oh, it's been declared illegal. The next, oh, keep obeying. How do you keep up? It's crazy. I don't blame you if you're confused and your head is spinning. Like I said here, so many laws, right? Your responsibility is to create the best possible plan for plan participants, administer it efficiently and effectively and in compliance with the law and the plan itself, educate the people who are involved, and be an advocate for your client. That's your responsibility. It's not your responsibility to research the minutia of every single law. There are people out there that can help you with that. I'm not necessarily saying you should pick one over another. I'm telling you, don't be afraid to ask for help. It doesn't look bad. It looks responsible. As far as consulting, if you think about it, every stage of a plan's creation, implementation, and administration has a number of different regulatory and compliance hurdles. Again, don't be afraid to ask for help, whether it comes from the plan drafting or you're getting questionable claims on either end of the life of a plan. It's okay to ask for help. And again, stay ahead. I joked before about how I used the Waze app on my phone for GPS, and I joked about how we're all headed to the same destination but taking different ways. One of the benefits of that app that I talk about a lot is it's crowdsourced. So one person reported that there's an accident right in front of them. I'm 10 miles down the road. I'm now being rerouted. So again, let us and let others in the industry act as a crowdsourced tool for you. You don't need to experience a catastrophic issue in order to learn from it. Other people have already suffered that same loss. Learn from their mistakes and avoid it in the first place. And as an industry, yes, I understand many of us compete with each other, but ultimately the greatest competition is coming from the government regulations, the government who's trying to make your life more difficult, making it impossible for you to offer these benefits, single payer advocates, things like that. Trust me, it's not the TPA down the road from your TPA that's going to put you out of business. It's the big picture. So focus. Thank you. Again, check your inbox. The newsletter is going to be sent, if it hasn't already been sent already, to prep you for the year. And once again, I just want to thank everybody for participating and joining us for this webinar. On behalf of myself, Brady, Jen, Matt, social media, you're the man. You've changed the way this company does its business from paper to electronic. I didn't know what email was until I met you. Adam and the Phia Group and all of its partners, allies, and friends, thank you so much for joining us today. Talk to you soon.